In this learning module, we're going to discuss the Miller factors. In order to discuss the Miller factors, it's important to see how they emerge in a line of cases through the United States Supreme Court. In 2005, the United States Supreme Court decided the case of Roper v. Simmons. This was a landmark case in which the U.S. Supreme Court brought together two strands of constitutional doctrine. One was death penalty doctrine, and the other was the children are different doctrine. And in this case, the court decided that as a class, as a group, persons who had committed crimes under the age of 18 would no longer be subject to the penalty of execution. What's important to appreciate here at this point is that the Supreme Court argued that because of their developmental immaturity, adolescents could never be amongst the most heinous perpetrators of the most heinous crimes, morally deserving of the most severe punishment. That simply their development put them in a different position than older adults. The court, as a result of that observation and the observation that it's essentially not possible to look at somebody at 14, 15, 16, 17 and reliably predict what their life course for potential rehabilitation may be, they decided to bar this penalty, the death penalty, for all persons under the age of 18. This doctrine was tested in a non-homicide case in 2010, Graham v. Florida. In that case, the court ruled that as a class, adolescents could not be sentenced to life without possibility of parole for a non-homicide case. But the tough case remained in front of them still. This difficult case came before the U.S. Supreme Court in 2012 in the form of Miller versus Alabama, which was a homicide case which would force the court to directly look at the possibility of life without possibility of parole for capital crimes committed under the age of 18. The Miller case is important for two reasons. First, it represents a departure from the approach that the court had taken in Roper and in Graham, barring penalties for that class of persons, adolescents under the age of 18, and it required the court to then substitute some process of decision-making in order for the court to decide who would be subject to life without possibility of parole and who would be given a lesser sentence at the time of sentencing following trial. In this particular case, the majority was short one vote of barring life without possibility of parole for a class of adolescents under the age of 18. And the compromise was to agree, the majority opinion, to bar mandatory life without possibility of parole, which many jurisdictions in the United States had at that time, a mandatory sentencing scheme for capital crimes. This, however, required the court to then give instructions to the sentencing judge to do precisely what they had said in Roper was not possible to do, and that is to distinguish whose capital crime, whose serious offense represented transient immaturity and whose serious offense represented a permanent incorrigibility, and only those who were permanently incorrigible were to be subject to life without possibility of parole, something that in dicta the Miller court instructed should be uncommon or perhaps even rare. And what were the factors the court were to apply, the so-called Miller factors? First, the court was to look at the developmental characteristics of young people, particularly immaturity, impulsivity, and impetuosity, sort of the three I's that reflect the still ongoing frontal lobe development of young people, which make them more prone to reckless and impetuous misconduct. They were also to look in the individual case to the young person's home environment, especially if it was a negative home environment, and by extension, one could argue, also their neighborhood, their community, because adolescents, they observed, have particular difficulty compared to older adults in extricating themselves from negative social environments, and they were particularly focused on the family and the Miller factors. They also understood that adolescents were different than older adults because of their vulnerability to peer influences. In fact, they were quite right. We now have the neuroscience to show that even if an adolescent simply believes that they're being observed by a peer whose opinion about them matters to them, that they have brain activation in reward areas that you simply don't see in the brains of older adults. The court was also concerned about the potential inexperience or even incompetence with which decisions might be made in their interactions with police in interrogation situations following arrest, or even in cooperating wisely, prudently, thoughtfully with their attorneys. And in fact, we do know from the literature that adolescents are more prone than adults to give false confessions in Miranda settings, and also to make decisions with their attorneys that actually work to compromise their own interests in the legal case against them. Finally, the court also wanted attention paid to the individual youth's capacity for rehabilitation. This is consistent with the neuroscience that shows us the sponge-like nature of an adolescent's brain that is primed for learning, for novelty. The problem, of course, is that in the Miller decision, the trial court was being asked to do, albeit by paying attention to these factors in the individual case, precisely what the Roper court had instructed was essentially not possible to do, or not possible to do reliably, which is to look at a child in adolescence and prognosticate what they were going to look like at 20, 30, 40, 50, 60. And in practice, courts following the Miller decision often did not pay structured, meticulous attention to the Miller factors. And in fact, in the Jones v. Mississippi case some years later, the courts were told that they needn't write specific sentencing opinions concretely considering each of these important Miller factors. So the Miller court was correct insofar that it identified these characteristic features of adolescence in their brain and social development, but unfortunately, attention to those factors in the Miller case itself has not yielded yet pervasive changes in legal practice as these cases go forward, and so it is still not uncommon for adolescents to be sentenced to life without possibility of parole following a Miller sentence hearing.